Welcome to the University of Maryland School of Law. It is my pleasure to welcome you all here. I was just going to say, one of the participants said, it's a little bit like a reunion. They're looking at each other, seeing how well they look after 30 years. Although I understand a lot of you have been working together on all sides since 30 years ago. Today's conference was conceived by the Maryland chapter of the Federal Bar Association with the goal of looking at the continuing significance of legal proceedings that involved Governor Marvin Mandel 30 years ago. In our tradition as acting as gathering place and shaping the debate on important public policy issues, the School of Law is welcoming this opportunity to act as a co-host for this event. The significance of this afternoon's discussion lies not with one person or the trials that involved him, as much as the abiding influence that those proceedings have now had on American jurisprudence and lawmaking. By providing this venue, our hope is today to give today's conference an academic focus that allows room for opinions and fair analysis. In that spirit, I would like to thank every one of you for being here today so that you can share your recollections and insights, and to our audience for what we hope will be a very stimulating conversation. Continuing our role at being at the center of public policy debate at the local, state, federal, and international level, this event actually takes place amongst a series of events going on in the law school over the last few days. Last week, Elijah Cummings, one of our graduates, led a congressional hearing at the law school, in fact, right in this room, on ways to combat drug abuse and related crimes in Baltimore. Yesterday, the law school celebrated with the Maryland Legal Services Corporation the 25th anniversary and our partnership with assuring that we expand legal services to our poor citizens throughout our state, and we continue the challenges of providing public interest law. This coming Monday, our students on the international front will be speaking about their role in law reform commissions around the world, as diverse as Hong Kong and Australia. And next Thursday, as a reminder to other very hot issues over the last few years, we will celebrate the 5th anniversary of Sarbanes-Oxley and discuss the laws passed and its future consequences on corporate ethics and governance. For today's conference, we have a number of very, very interesting guests, and I'm going to leave that to our next introducer to introduce all of them. But I am sorry that that Governor Mandel was not able to join us today. But I did want to let you know, Governor Mandel graduated from this law school in 1942. That means 65 years ago. And to this day is working hard now as a regent of the University of Maryland system. And while as a student at the law school, he told me proudly last year that he still wears his buckle, his belt buckle. Those of you who know Marvin Mandel, if you look closely at his belt, there will be a belt buckle, because what it says on it is winner of the moot court competition. I'd also just like to welcome a number of our lawyers around who are also very proud graduates of our law school, and a particular welcome to Arnold Weiner, who for many, many years has been serving on our Board of Visitors and, as you all know, had a very active role in the Governor Mandel trials. So at this point, it is my pleasure to introduce Cy Smith of the Maryland chapter of the Federal Bar Association. Cy is a partner at Zuckerman Spader here in Baltimore, and I think in many ways the brainchild behind today's event. So Cy, thank you very much. Thank you all very much for coming.
I want to thank Dean Rothenberg for her kind remarks, and I want to thank the entire law school for helping us to put this program together. As I'll explain in a minute, this is not my brainchild. The credit belongs elsewhere, but it's been a terrific effort putting all of this together. and getting a lot of help from the law school, not just from Dean Rothenberg, but from Dean Michael Van Alstyne, and especially Mary Jo Rodney and John Stylick, who did a ton of work to get this event underway. But I want to thank the person who actually came up with this idea, and that's Jeff Gray, who's seated up here, and you'll hear from him later. He'll moderate our second panel today. Jeff, who, as many of you know, is an assistant U.S. attorney here in Baltimore, has long been a student of the law and of legal history. And it was his idea more than a year ago to mark the 30th anniversary of these trials by putting on this sort of program, and it sort of went from there. Actually, earlier in his career, and Jeff will speak about this, he represented the United States in proceedings to forfeit money from the estates of several of the defendants in these trials. Even though it was 30 years ago, we are very fortunate to have so many of the participants on both sides of the bar here alive and well and joining us today. Sadly, there is one very recent exception. Phil Sutley, who many of you know, who is a lawyer here in Baltimore, who was co-counsel for defendant William Rogers, and it's described in page 10 of your program. He died last week, and he died just outside the old federal courthouse on Calvert Street, Courthouse East, which is where the first trial began in 1976, although it later finished in the Garmatz Courthouse, which is now on Lombard Street. And we, of course, mourn the passing of Phil Sutley. I want to talk for just a moment about why we've chosen to mark this 30th anniversary. You know, why is 30 years significant? What was the enduring significance of these trials? You'll hear about that probably much more interesting terms than I can describe in just a moment. But it was the 1977 trial in which Governor Mandel and his 5 co-defendants were convicted of mail fraud and RICO violations. Those convictions, of course, were later vacated as a result of the Supreme Court's ruling. One big reason we're having this event is that we think that there are just going to be a ton of terrific stories coming out of this. You have Governor Mandel, the progressive, respected governor of Maryland, a man who accomplished great things for the state of Maryland, and in many ways is known for those even today, who was brought to trial in federal court here in Baltimore, and later to have his sentence commuted, his conviction later reversed by the U.S. Supreme Court. But you're going to hear from the attorneys who represented both the defendants and the prosecutors, the people who wrote the indictment, tried the case twice after evidence of jury tampering came to light. You'll hear from the TV and print journalists who covered the quintessential big story back in 1977. We'll talk about how that's changed today. And that's in our first session, which is focused on the trial itself. We also thought it would be of interest to look at the fallout from the trial. There are some enduring legal points that come out of the trial, and that's the focus of our second panel. And the Mandel trials also mark the end, partly by coincidence, but partly because of the evolution of history, of an era of machine politics here in Maryland. The old party machines, which did a lot of good for a lot of people, but they eventually began to decay and to atrophy, and that happened at roughly the same time that these trials were taking place. So it was the end of an era of politics in Maryland, and that's the focus of our third panel, which will also look at lobbying in Annapolis, then and now. The key point here is that 30 years allows us to have some perspective, some academic perspective, some historical perspective, some legal perspective. Some people that you may hear from in a few minutes, they're still back in 1977. They're still trying to decide was a crime committed, and you'll hear that as well, and that should be fascinating, assuming that no one actually comes to blows. And a lot of people here, I see many younger faces out here, a lot of people may not remember the trials at all. It may be new to you, and I think we all know that it's important to learn from history, or at the very least to know your history. So we look forward to showing you a little bit about that. You're going to hear in just a minute, and I recognize that you want to hear from someone who's not just a talking head, but you're going to hear very shortly from Katie McDermott and Stephanie Gallagher, who will touch on some of the highlights of the trials to put them in a perspective for you, or if you don't actually know the facts, to tell you about those facts. They'll be using technology which was not available 30 years ago in order to do that. Stephanie is an assistant U.S. attorney. Katie is a former assistant here in Baltimore. Katie is now a partner at Sonnenschein Nath in Washington, D.C., where her practice focuses on health care and regulatory and white-collar matters. One remark about the program materials you have, everybody should have a little bound thing and then a CD. The bound piece has a guide to the participants and a chronology of the trials. The CD you received has copies of a large number of key documents from the trials and the appeals, including the indictment, the opening statement, remarks at sentencing, and the like. They were all prepared for us by Rick Carter of Lex On Demand here in Baltimore. We couldn't get their logo up here, but They were done free of charge, so I urge you to send him your business. What's that? Excellent. And we'd like to welcome all of our guests, and I see that the vicissitudes of Washington traffic have not prevented everyone from joining us. We welcome Andrew Mitchell, who you'll be hearing from momentarily. I want to make two corrections to your program. The first is that we mistakenly omitted Chris Olney, who's a leading trial lawyer here in Baltimore, from the list of defense counsel. He served Governor Mandel well at both trial and on appeal, and he's threatened legal action unless we point out that he was involved in these proceedings, so please write his name in using a Sharpie, and we'll be done with that. Second, I'm not sure if Susan Meyerberg is here. She represented William Rogers along with Bill Maher and Phil Sutley. She then became an entertainment lawyer on Broadway in New York, where she co-produced the original Driving Miss Daisy, and I want to make note of that as well. We're fortunate to have with us a number of members of the federal and state judiciary. I want to welcome them as well. Also, a number of members of the legislature. Thanks for coming as well. So we look forward to some uninhibited, robust, and wide open discussion of the issues today. And with that, I'd like to introduce you to Stephanie Gallagher and Katie McDermott.
Of course, I can't say we've mastered any technology in the less than 30 years we've been doing these things. Good afternoon. We'd like to start with a very brief timeline to orient you a little bit more to some of the issues in this case. In 1977, the President of the United States was Jimmy Carter. The cost of a first-class stamp was 13 cents. There was a really interesting song, You Light Up My Life, by Debbie Boone, which I hope you're not humming all weekend. And the average price of a gallon of gas was 62 cents. Also, the U.S. District Court for Maryland was the site of, as Cy has noted and all of you know, a historic trial that really brought together in fateful collision law and politics and ultimately resulted in the indictment of a sitting governor and his political friends for fraud and racketeering based on a legal theory that many years later was rethought, and the governor's conviction was reversed. How it all started with the legendary trial, like many political stories in Maryland and many legal stories, it starts with a racetrack. And even today, we still have racetrack stories. Stephanie, help us understand the sequence of coincidental events.
What started in May 1971 when Governor Mandel vetoed a racetrack bill that was designed to transfer racing dates from one track that was now defunct to the Marlboro racetrack. And the effect of that bill would be to increase the profits of the Marlboro racetrack. In December, actually it's December 1971, the Marlboro racetrack was secretly purchased by a group of political and personal associates of Governor Mandel. In the beginning of 1972, the first night of the General Assembly, sitting in January of 72, had been lobbied by Governor Mandel to actually override his veto of the racetrack bill. They did override that veto, and they thereby unknowingly giving lucrative financial benefits to those new owners of the Marlboro racetrack. In March of 1972, about 3 months later, Governor Mandel again used his office to lobby and persuade the General Assembly to pass another bill authorizing additional racing days for that racetrack and further increasing the profits for the owners of the racetrack. In 1975, federal law enforcement authorities were investigating whether Governor Mandel had received bribes from those owners of the Marlboro racetrack in exchange for his efforts and the use of his position to assist the track. And this culminated in an indictment on November 24th of 1975. The federal grand jury returned the indictment charging Governor Mandel and his friends and associates with offenses including mail fraud, racketeering activities, and aiding and abetting those offenses. Specifically, the indictment charged that Governor Mandel had used his office to benefit his co-defendants without disclosing to the General Assembly his relationship with the owners and the true owners of that business entity. The co-defendants, in return, according to the indictment, provided financial and other benefits to Governor Mandel. And the indictment further charged that Governor Mandel had falsely reported the financial benefits he had received from his co-defendants in his federal income tax returns. The theory underlying the mail fraud charge was that the defendants had used the mail in furtherance of a scheme to defraud the citizens of Maryland by depriving them of the honest services of their governor, Governor Mandel. And obviously this was a seismic news event that rocked Maryland.
And we want to thank Marty Himmelis for giving us some of these headlines to put in our PowerPoint regarding the indictment itself.
And Katie will address what happened when the case went to court.
The case originally went to trial, and the governor and his political friends appeared in front of a jury of their peers, and this is a rendition of the jury in the late 70s. There was a great deal of trial mischief in connection with the prosecution. There were allegations of jury tampering. There was a decision not to give a mistrial, then to give a mistrial, and we find that we had to bring in actually judicial officers, judges from other jurisdictions actually presided over the case. So we find that in 1976, in December of 1996, finally there was a mistrial eventually granted for jury tampering. A new trial was granted before U.S. District Court Judge Robert Taylor from the Eastern District of Tennessee. The governor in the second trial actually testified in his own behalf, and some of these renditions illustrate, I thought him smoking his pipe actually in the courtroom, but I doubt that was true. Maybe the defense counsel will let us know if that occurred from the illustrations. And finally, in 1977, on August 23rd, the jury returned verdicts of guilty for each defendant on 15 counts of mail fraud and 1 count of prohibited racketing activity. And then, Stephanie, a very long odyssey began.
A very long odyssey began with the appeals. In 1977, Governor Mandel was sentenced to 4 years in prison, and as a result of his conviction, he was also disbarred. In January of 1979, a 3-judge Fourth Circuit panel reversed the convictions in the Mandel case, finding that the jury instructions on the mail fraud counts had been inadequate. In July of 1979, after rehearing the case en banc, the convictions were affirmed by an equally divided court, 3-3, and the effect of that equal division was to reinstate the district court decision which had upheld the convictions. After 2 new judges were appointed to the Fourth Circuit, they tried again for a rehearing, but by a vote of 4-4, the court declined to have another rehearing of the defendant's appeal, and the convictions remained in force. In 1981, December of 1981, President Ronald Reagan commuted Governor Mandel's sentence after Governor Mandel had served 19 months in prison. He would actually have been eligible for parole 5 months later. And in 1987, the Supreme Court weighed in and actually changed the legal theory on which Governor Mandel's conviction had been based. In McNally versus United States, the Supreme Court held that the mail fraud statute, 18 U.S.C. 1341, does not protect against schemes to defraud persons of intangible rights, such as the right to honest services from government officials. And that sort of crumbled the legal underpinning of the conviction.
But there was still more to do in the District Court of Maryland. So the defense counsel filed a writ of coram nobis. We say coram nobis what? It's the Hail Mary of pleadings to help folks that have been convicted, serve their time, and then the legal theory has been discredited. So Al Faginski and Stuart Berger were involved in filing a writ of coram nobis in front of Judge Smolkin, who eventually granted the pleading, and then began another process of appeals to try and determine whether this conviction could stand. The Fourth Circuit affirmed Judge Smolkin's granting of the writ, and the government's petition for a writ of certiorari was in fact eventually denied. Governor Mandel then returned to the bar as a member, reinstated. The Court of Appeals of Maryland ordered that it be reinstated July 6, 1989. And Judge Smolkin issued shortly thereafter, in 1994, what might best be described as a judicial curtain call, when he issued the final orders on all of the legal proceedings that came out of the Mandel prosecution and ancillary litigation involving forfeiture, property rights, and other issues. And that was the end of the case, originating in the late 70s. Thank you.
With that timeline in mind, let's go back to 1976, 1977. We're very pleased to have a terrific panel that looks at the trial, and it's going to be led by someone who both has personal knowledge and because he was there at the time, and also is an accomplished trial lawyer in his own right, Mike Schatzo. Mike Schatzo is a partner at Venable the now one-word law firm behemoth here in Baltimore and points north and south. He was actually there at the trial way back when. He's a terrific person who has also recently been named Outstanding Lawyer at Venable Baker and Howard, or Venable LLP. Please welcome Mike Schatzo for our first symposium.
So I got it. It's not quite that. I'm far from the most outstanding lawyer there. Thank you very much. I want to introduce the participants, but I'm going to do this briefly because I'd really like to get to the meat of the discussions. So there's a great deal of information about them that appears in the program. I'm going to just talk about the role that they played back in the day. Lee Balin, Lee, wave so people can see who you are. Lee covered the trial for the Evening Sun, and his career's gone downhill. He's a lawyer now.
I'm going to be a used car salesman next.
You're on your way.
Try honest work first. That's right.
Well, the key word there would be work. That comes from a judge. That's Chuck Bernstein, who represented Ernie Corey at the second trial and is now a judge here in Baltimore City. Chuck had so little faith in his assistant at the time that he insisted that Bill Brennan, who had participated with Joe DePaul in representing Ernie Corey in the first trial, also participate in the second trial, which Bill did, and Bill represented Ernie Corey in that trial. As Bill is fond of saying, Ernie Corey is the only defendant who did not go to jail. Tom Green represented Harry Rogers. Tom, you've probably seen on TV. He's involved in almost every significant national case. Dan Herson, over here on the prosecution team, was one of the three chief prosecutors in this case. Sitting next to him is Ron Liebman, who was also on the prosecution team. Mike Marr represented Bill Rogers, or as Mike characterized his defense, Bill who? And here we are honored to have with us Andrea Mitchell, who is the chief foreign affairs correspondent for NBC News Now, but back then was covering the trial for Channel 9. And because of some breaking developments, Andrea may have to leave early. She's going to try to stay, but if she leaves, I just want you to know how grateful we are for you taking the time out of your day to come here. Next, I want to say a word or two about Barney Skolnick. Somebody said this is like a reunion. At a reunion, you always give a prize to the person who comes the farthest distance, and that would be Barney. But I also want to just say a little bit more. Barney was the lead prosecutor in this case and in many significant cases, and there are many people in this room who either are assistant United States attorneys, or indeed we have the United States Attorney for the District of Maryland here, or who were former assistant United States attorneys, or people who worked in the office. And all of us who were in that office, or are in that office, owe a huge debt of gratitude to Barney Skolnick. His body of work really raised the prestige of that office immeasurably and nationally. And it is hard to imagine, as you sit here with all the wonderful lawyers in this case and all the wonderful work that went on, this was not the most significant case Barney Skolnick prosecuted. Barney Skolnick prosecuted a sitting vice president of the United States. He prosecuted county executives throughout Maryland and 2 congressmen. And everybody associated with that office owes Barney a large debt of gratitude. And I personally am grateful that he came down here to participate today. And then finally, Arnold Weiner, governor's chief lawyer, dean of the trial bar here in Maryland. Success then, success now, and we'll never stop. So that's who we have here, and I'd like to kick it off right away with asking Andrea Mitchell a question about coverage and what were the challenges, what was unique about covering this case, and how, if at all, has press coverage of these kinds of trials changed?
Well, first of all, thank you very, very much, because this trial had enormous impact on those of us who covered, and particularly on me. I was young and new to the area. I was, in fact, recruited to come here to cover the retrial because I had been covering politics in Philadelphia, and the people at Channel 9 decided that anyone who had covered corrupt politics in Philadelphia by Frank Rizzo, then the mayor, was the right person to cover this trial. You can draw your own conclusions, but Baltimore was certainly, because of Barney and the Agnew case, was a significant national force in terms of the prosecuting team, and local politics were, of course, fascinating. The differences are enormous. When we first started covering the Mandel case, we were working with film crews, and I would typically cover the morning and early afternoon testimony with wonderful courtroom artists, in my case, Roxy Monroe and her sister Anne, and then we'd get into my car and we'd drive along I-95 back to Washington because we had no live satellite capability. It didn't exist. And we would drive along 95. Roxy would be painting in the back seat and then waving the art cards out the rear window to dry. And I would occasionally get stopped and given speeding tickets, and eventually get back to the district, put the art cards on 2 easels in the studio. Gordon Peterson and Max Robinson, the late Max Robinson, would be sitting there. Typically, I'd be sitting next to Gordon, and we would alternate back and forth with the 2 cameras. And I would be ad-libbing my script or reading off of notes, handwritten notes. And to try to explain to some of you, we didn't have computers. Midway through the trial, we got the first satellite truck. And that's when these trucks would roll up at the courthouse in the Horseshoe and try to get a live feed out. And it was all cabled and very complicated. And that's when we would start feeding back the artwork by videotaping it and feeding it back. And then I would read, paragraph by paragraph to match the artwork, and they would edit it back in the studio. But the primitive nature of all of this is in contrast to the Scooter Libby case. When our correspondents and producers were covering that case, they were on their laptops and Blackberries and were reporting on a hookup from the courtroom, even though it was a federal courtroom, obviously, and didn't have video cameras. They were able to report the verdict live. When there was the possibility of a juror during the 113 hours, I think, of deliberations, which may still be a record, I'm not sure, in a federal case. When one of the jurors in the Mandel trial was seen leaving in an ambulance at one point, and I recall chasing down that driveway towards the ambulance to try to spot who it was through the back window of the ambulance, and tripped and fell, and we all ended up in the same ER. And there was some fear that, from the U.S. Marshals, I think, that there would be another mistrial because I was in the ER being treated for what turned out to be I forget whether it was a twisted ankle or whatever, but I ended up on crutches covering the verdict when it eventually did take place. So all of this was light years technologically away from what we now are experiencing in television. But most significantly, and perhaps because it was such a big deal and it dominated the news here in Maryland and in Washington and nationally, and I ended up covering the appeals for NBC News after I went to the network. And of course, going back when we asked the governor, are you going to take back your office and become governor? He said, I am the governor, as I recall, and always was and always would be. The difference then was that a story such as this was the most important story in print and on television. And I think our standards have changed significantly, and that perhaps because of technology and because of the way our audiences are now fractioned by so many different competing media, that perhaps all of the digital advances that have brought instantaneous coverage have not necessarily deepened or added more texture or context to what we do. But perhaps it's memory, faded memory. I know none of us have changed looking around this courtroom. That none of us have aged or changed in any way, but it does seem as though those memories are extraordinarily fresh, vivid memories of a very important case in the lives of everyone in this room, and all of our readers and viewers and the people affected by the law that was made here, and the law made subsequently in all of those many years of the appeals. It just seems to me that we cared a great deal more about the principles involved and the details, significant details of a case, and spent a lot more time. I know in our case, the late Jim Snyder, who was my news director, said, I want you to cover this case, and this is going to be the most important thing you do, and we are going to own this story. And when I now talk to Maureen Dowd and several of the other alumni of this experience, many of us feel it was the most important trial we ever covered. And so
Well, thank you, thank you.
all of those changes, that will never fade.
Thank you. Tom Green, the last 30 years, you've been involved in virtually every significant national case. What, from your perspective, if anything, has changed in terms of how you deal with the press, how you try to work the press to your advantage, or how do you try to stay out of their way?
I think when we were all younger at the Mandel trial, and Andrea, you do look the best among this group, it was a lot easier to engage with Andrea and her colleagues in that time period. It was a very honest relationship. It was a trusting relationship for, I think, all lawyers on both sides of the case. And you felt that when you interfaced with the press, when you talked to the press, they would be honest and reliable in reporting what you said, if indeed you were on the record. It's a much different story today, at least it is from my perspective. And I think when you represent someone in public life, a politician, the core issue is whether you do engage with the press today. And it's a very, very delicate decision. The thing that we confront, or I've confronted over and over again in many of these cases, is there's a lot of information that gets leaked. And whether it's deliberate or whether it's inadvertent, both sides, the government and the defendant and his counsel, are claiming that each side is purposefully leaking. But that presents its own range of issues, and I've found that you have to balance the decision to engage with the press on one hand with the reaction it has with the prosecutors on the other hand. There's a lot of things that we can do to try to manage the press, lots of things that we can say, lots of information we can release, which just stimulates in many ways the prosecution and the prosecution efforts. And I don't believe there's a general rule for how you do it. I think it's a very, very delicate decision. I try to keep my clients from having to take on the allegations in the press, frontally if I can. But because they're in political life, they often feel compelled to respond. And managing those responses and trying to refine them so that they don't cause further damage to the effort at defending these individuals can be a difficult prospect.
Thanks, Tom. Lee Balin, you covered the trial for the Evening Sun. You had a couple of experiences that Tom was talking about where people did talk to you off the record, but very directly.
Well, the thing, and thinking as Andrea was talking, that the major change that I perceived over the years while I was still a journalist was one of access. And I think Tom honed in on the relationship. There was I think a much more open and trusting relationship early on that's changed dramatically. And I don't know whether it was perhaps Watergate, maybe the Gary Hart case, some of those things that changed that. When I arrived in the federal courthouse to cover it in 1969, it was about the same time Barney arrived there, and it wouldn't have been unusual for a couple of assistant U.S. attorneys and me and a few secretaries to be sitting around one of their desks at lunchtime eating pizza and playing cards. The federal courthouse would crumble today if that happened. The defense lawyers actively engaged in managing the press. Bill Hundley, the late Bill Hundley, who's not here among the defense lawyers today, was probably the past master at it. Bill always loved to tell a story about how he was representing Tong-Sun Park in the Koreagate case, how he had to explain to the Korean secret police why the Washington Post reporter was filing his stories from his hotel room. These things don't happen today. I mean, early in the morning, typically I could be in Judge Pratt's chambers having a 15-minute off-the-record conversation with him. I don't think that happens with federal judges today. So it's that whole relationship that's changed, and I think maybe Watergate, maybe the idea of we have got to go get them and go get them hard from the press side changed the reaction on the other side. I mean, the transition I left journalism in 1984, and just before I left, I was a law student and back covering federal courts again, and the U.S. Attorney's Office tried to have me barred from the courthouse library up on the 8th floor where I was working on a moot court brief because I might accidentally see an AUSA up there doing some research. Now that's how dramatically it changed from '69 when we'd eat pizza around the desk to 1984 when they didn't want to share a public library with me. So there have been a lot of transitions over the ages.
Thanks, Lee. All right, Arnold, you got a new jury here. Tell us why this wasn't a crime.
It wasn't a bribe. It wasn't prosecuted as a bribe. This was a political corruption case that was the best you could get with one exception. There was one thing missing from it. It had great defendants. You had a sitting governor who not only was very active as a governor, but whose personal life was very much a soap opera. He left the State House very much the way Rudy Giuliani left Gracie Mansion, and that played out. You had a crack prosecution team that was thirsting for more blood after Agnew and 2 county executives. You had a Baltimore Sun that absolutely despised Maryland politics as it was and absolutely despised Marvin Mandel and his friends. It was very hard when you would read the articles to tell whether you were reading news articles or opinion pieces. It was sort of like the news you get on Fox News, except the other way. And Erlanger, who wrote some of those articles, is giving me this. And the Sun paper in those days was much, much more influential than it is now because there was a morning Sun and an evening Sun. So if they didn't get you in the morning, if Erlanger didn't get you in the morning, Balin hit you over the head at night. And that was the atmosphere in which it all played out. The one thing that was missing was a crime. Now, there was Mandel had his friends. His friends were good to him. They helped him out when his divorce took place. They helped him get suits for his honeymoon, and unfortunately, one of them tried to save some income taxes and charge it as track uniforms, but which wasn't exactly a great exercise in judgment. But except for those lapses in judgment, you didn't have the facts and you didn't have the law to have a real prosecution. The interesting thing is, and I would take issue with a summary of the facts as given by a prosecutor. The whole theory of the Mandel case was that Marvin Mandel did nothing when a veto of his was going to be overridden. And the crime essentially was in doing nothing. And it was proven by having a bunch of state legislators come up, most particularly Jack Lapidus, to be allowed to testify. I saw a snake slithering across the state Senate floor. I knew something smelled. There was something horrible. We knew that if the veto wasn't upheld, it was because Mandel wanted it that way. And that was the criminal act. This business about the governor's staff, by the way, going around to promote a bill, that was never established, and it was because of all the snake slithering around testimony that the conviction was originally set aside 2-1, in part because there was evidence that was inadmissible, and in part because of this whole mail fraud business. Now that then brings us to the legal basis. This case never had a legal basis. It just didn't have it. The mail fraud statute had been enacted in the mid-19th century to prosecute bunco men, to prosecute con men. It had nothing to do, as it was then enacted, with political life. And the federal government made a number of efforts to try to criminalize what they couldn't prove as bribery, and that's they could easily have charged a bribe, but they couldn't prove bribery, so they brought this silly mail fraud theory. The problem was that you had 2 circuits that had spoken on the issue before the 4th Circuit spoke. The 5th Circuit, where Louisiana and New Orleans is, and that's another one of the axes of corruption, the 5th Circuit had said you can't use the mail fraud statute for this purpose. It's taking a statute that has nothing to do with it. It's bastardizing the criminal law. It's criminalizing after the fact conduct that isn't criminal, conduct that should be left to the voters. The 7th Circuit, on the other hand, where Chicago is located, and which is the other part of this axis, Chicago had its problems with Governor Kerner and with several people on the mayor's staff. And the 7th Circuit came up with this imaginative idea that you can use the mail fraud statute for this purpose. The 4th Circuit then, and the Maryland District Court, wrote on a blank slate. Are you going to accept as the whole basis for prosecuting a sitting governor a doubtful or at least questionable interpretation of the mail fraud statute, or are you going to look for something else? Well, they obviously looked for something else, and it wasn't there. And so the prosecution was based on this questionable view of the mail fraud statute. And at every turn in the case, that was our complaint. This is not a mail fraud. These people should not be prosecuted. They didn't commit a crime. Well, we went through 2 trials, and even on the most generous view of the law that they had, the jury was locked up for a week. They reported themselves deadlocked twice, and the judge essentially told them, if you want to get out of that jury room, you'll return a verdict. And it almost looked as though the jury was locked up for the whole trial too. It almost looked as though the jury was going to spend more time in jail than anybody else. Well, you finally get this forced jury verdict. You get the 2-1 reversal. And on the 4th Circuit was Harrison Winter, who unfortunately was politically allied with some of the defendants, and so he recused himself. And Harrison Winter was a guy who would never have voted for this, and it was only because of his absence that the next craziness occurred, and that was the court splitting 3-3. And it was the first time in my life, and maybe the only time, I saw people who were going to go to jail on a tie vote. And then 2 new judges got appointed to the court, and they split 4-4. The case then went to the Supreme Court, and the mail fraud issue was squarely presented in the petition for certiorari. The problem was, and it was widely discussed, Warren Burger was Chief Justice at that time, and Warren Burger had a very strong personal dislike from these fellas, whether it was from watching Channel 9 or reading the Post. I know Lee Bail and stuff didn't get to him. But
It was your fault, Andrea, not mine.
it was widely reported that Berger just couldn't bring himself to vote for certiorari, and that he was actively lobbying the rest of his brethren, and they could never get a fourth vote to grant cert. And the petition sat for an inordinately long time. It may have been almost the entire term of that year, and finally they decided not to take the case. And it was only 10 years later when they took McNally, which involved this minor little guy from Kentucky, that a slightly different Supreme Court viewed or finally agreed to tackle the subject. And when they finally tackled the subject, they declared what probably everyone should have understood all along, which was that under the mail fraud statute, as it was then written, what Marvin Mandel and what a whole lot of other people up to Mr. McNally were charged with simply was not a crime. Now, to give you an idea how impartial the Sun Papers was, that when the Mandel conviction finally got struck out on the ground that nobody had committed a crime, the Sun paper wrote an editorial saying he had gotten off on a technicality. Well, that's the technicality we all try to get people off on, which is that they didn't commit a crime. And for me, the question always is, there never was a question of the motives of the prosecutors here. These were first-class, terrific prosecutors, were as good as the federal government has ever had. And there was no question of the bipartisanship or the nonpartisanship of the Justice Department. This Alberto Gonzales was not there at the time. But what you had, though, unfortunately, was a momentum that gathered. It started with Agnew. It continued through the county executives. There was an aura of invincibility that was brought in my judgment, was brought to this prosecution. And were I making judgments, and I didn't make the prosecutorial judgments, but were I to make a judgment in a case where the facts are very weak and rely a lot upon somebody thinking he sees snakes going across the State House floor, and where the law is at best dubious, I think I would have hesitated before bringing a prosecution against the sitting governor and causing what I think was a lot of unnecessary havoc, and in the end, I believe, a terrible injustice to a guy who not only had his political life ruined, but also went to jail for 19 months for something that was not a crime. And there's no one to blame, but it just seems to, all right.
All right, well,
There's no one alive to blame, but it just seems to me that that's my perspective on that case.
Thanks, Arnold. So now I'll ask the question to Barney, Ron, Dan. Let's see. It wasn't a crime, so why'd you prosecute him? You had no evidence. How'd you convict him?
I'll start. That was Arnold's a wonderful lawyer, and that was a brilliant, very, very scholarly argument. I think longer than the argument he gave in the case, but just as good. Fact of the matter was, it was a bribe, and it was prosecuted as a bribe under the mail fraud statute. And it really isn't that complicated. The case had a legal basis, and it had a factual basis. The legal basis was that at the time, there was no McNally decision. There was good authority, federal law, that under the mail fraud statute, when someone was defrauded out of property, property could be the honest and faithful services of a public official. That was the law. And before McNally, that's what the district court and the Fourth Circuit ruled. Let me stay with that for a minute, because one of the things that was left out of the slide presentation was that after the McNally decision, and while the Mandel case was bouncing around like the proverbial John Dice v. John Dice in the courts, the United States Congress amended the mail fraud statute to make it clear in the statute that one could be defrauded as property out of the honest and faithful services of a public official. So that if today this case were brought and Marvin Mandel were the defendant along with the others, and he went to trial and he was convicted, his conviction would stand. That's the technicality. That's a matter of timing. But it isn't that complicated. Marvin Mandel probably wasn't the worst person to walk the face of the earth. He was a good governor. But he grew up in a system, a culture that existed in Maryland, and ended pretty much, at least for a time, I guess, who knows what the future will bring, with his case. A system that he didn't create, that he bought into, where you had friends if you were a public official. Your friends took care of you secretly, surreptitiously, not out in the open, under the carpet, and you took care of them. And that's bribery. And that's what that case was about, and it's still about. Before Marvin Mandel, there was Spiro Agnew, there were a lot of others. It was machine politics. And what this case did, if you put the proverbial bouncing ball, how this case went up and down through the courts, out in full public exhibition, was that Maryland, like other states, Louisiana being one of them at the time and probably forever, had a system of corruption. And Marvin Mandel grew up in it, and it isn't complicated. He participated in it, and that's what he got convicted for. It's really that simple.
Dan, you had some views about sort of going to the question of the exercise of prosecutorial judgment, about how that judgment got exercised 30 years ago versus how it gets exercised today. Talk about that for a minute.
Yeah, Mike, what most people don't know about all this is all the work that went into this case before the indictment was handed down. The three of us spent 18 months with a federal grand jury. Hundreds of witnesses went through that room, no defense lawyers. But the case was very tightly put together, and then we had to take it to the Justice Department. And we went down there. First, we talked to Dick Thornburg, who was the head of the criminal division. And we talked to John Dowd, who many of you know, who is a prominent lawyer in Washington and was then the RICO man at Justice. And this was one of the first cases to use RICO, and so we talked to him. And then we had a meeting. I'll never forget it. We went to the Attorney General's office, and he and his staff, and his name was Edward Levy. He was a very distinguished academician from the University of Chicago. He was a class act, and he was very smart. And he sat there puffing his pipe, and he asked us all these questions about this case. And I was scared to death because I thought he was going to decide, well, and that'd be that. But he didn't. And that process was above board. It was solid. No politics. Nobody ever accused. There were a lot of accusations about this case, but never was it ever accused that there was any political motivation. And I would hope that, you hear these things nowadays about this matter with the governor of Alabama and what happened to him and all the affidavits that are flying around. I just hope that somehow or other we can return to a situation in which everything is done that way and has the prosecution is based on the facts.
Okay, thanks, Dan. Well, let's, if we can we get somebody to talk about trial tactics? Mike Mark, and I point the finger at you and ask you to talk about whether there were differences among the defense group about how to proceed, whether there was difficulties keeping people in line, whether you were part of the problem or part of the solution. Anything you'd like to talk about on that subject?
Well, I can truthfully say that my role in the case was extremely limited, since I represented William Who. There was really no evidence that I could see that really touched him, except in terms of the argument that the evidence touching others had an impact on him indirectly. As far as trial tactics were concerned, I think that there was, if not in writing, there was certainly a joint defense agreement to handle this case jointly. I do know that in this particular case, I felt very strongly and got an indication that my perception was proper, that had the first trial, the one in 1976, concluded that even before it went to the jury, that the court would have granted a judgment of acquittal for Bill Rogers, because there was really no evidence that touched him directly at all. And there may be differences of opinion on the other side. I see some smirking over there, but that's fine. That's the way it is. And I think you can assess from your own perspective here today the different points. One of the things that wasn't mentioned about the first appeal, where the decision was 2-1 against the government's position in this case, was an evidentiary issue. And we've heard Arnold very eloquently refer to it as the snakes. I mean, there was some questionable evidence in that case that was allowed in. There was a lot of hearsay that I thought didn't even pass muster, even under Section 25 of the hearsay rule. That is the one where the kitchen sink comes in. But in terms of tactics, I think we all got along very well. Most of us who were at that table, were at the trial table, were constantly in touch with each other. I know I was very young at the time. I think it was the youngest one there, and Tom and I were talking, Tom Green and I were talking, we were about the same age. He's a little older than I am, you can tell by looking at him. But anyway, you know, it was a learning experience for us, the youngsters. Guys over on that side, too, were young. A learning experience for all of us. Nobody questions the rectitude of their opinion that they had a proper case to bring. The question is, that's their opinion. On this side of the table, we always felt that the case never should have been brought. I mean, I was quoted in the New York Times, I think, during the 10-day or 14-day or however long it was, second-day trial, as from the very beginning, this was an ill-starred case. It always was an ill-starred case, and it always will be an ill-starred case. I think it's obvious if you examine carefully the details of all of the appeals in this case and all of the collateral opinions in this case, which I know there's going to be some discussion coming up next, you'll see that from the developments in the legal realm, there was always a serious question as to whether or not this case should have been brought in the first place. You heard it very eloquently expressed by Arnold Weiner, and you've heard it eloquently defended by Ron on the other side. But it's a close question. And I remember in my days as an assistant U.S. attorney, I would not darken the door of a grand jury unless I was certain that I could convict a defendant. And I think that's why that very, very capable, eloquent, and wonderful office, by the way, best job I ever had was being an assistant. Still feel that way after many, many years later, and probably most of you who are in private practice do as well. But that's why that office has such a high success rate, as well it should, because they have an awesome responsibility to protect the innocent and to only go after those that they can truly convict for an offense that was for which the defendants are truly guilty. In terms of strategy, I think that those of us in the case, we bonded together. We dealt with it practically speaking, even though there was no written joint defense agreement as a joint defense. I can remember how difficult it was after a consultation with my client to join in the motion for mistrial at the end of the second effort to tamper with the jury, because had I not and resisted it strongly, I may have been able to interpose a successful double jeopardy argument, although in those days that whole argument was very nascent and probably wouldn't have succeeded, certainly not in this circuit.
Thanks. Tom, you wanted to say something?
I've got a little different take on trial strategy. When I was a prosecutor, I loved multi-defendant trials because I always felt that I could kind of relax and let the defendants knock each other out and help me in my case. And I think I probably made a mistake, actually, in this trial as a young lawyer. I succumbed to the proposition that we should be united, and we should minimize the arguments between us and the divisions that might otherwise exist with respect to the quantity and quality of the evidence. The Rogers brothers, while certainly they were not totally below the radar, were you know, there was no comparison to their notoriety next to the governor. And there were opportunities in that trial to differentiate what they did or didn't do in much starker terms than I actually undertook to do. And I fault myself for that. It's hard to second guess and know whether it would have impacted the outcome, but clearly I could have attempted to differentiate my client, and in that respect both Rogers, from the conduct of Mr. Hess, from the conduct of Mr. Covens, and in some respects from the conduct of the governor. But I didn't do it. And now, 30-some years later, and a jillion trials later, and a lot of political trials later and so forth, I probably would have done it differently if I had to do it all over again. Would do it differently.
Lee?
Interesting, Tom, because it sort of fits into one of the anecdotes that I was wondering whether I'd talk about or not here, and I think it works. It sort of fits right in here. There came, I guess, at the end of the first trial and the second trial, about once or twice a week, also taking off on your idea of the relationship with the press. We wound up having dinner with my colleague Nick Yangich and I, and most of the times Don Baker from the Post, and Bill Hundley, and most of the time Dale Hess was there. And in the course of some of those discussions, Dale and Bill pretty much put out the idea that were it not for Marvin digging in his heels on this case, they would have worked the plea agreement out, done some time, and been out of this case and moved on with life. And I'm wondering if that was ever a consideration for the Rogers brothers, too.
I never had that conversation with my client.
I can tell you.
And humor aside, the circumstances weren't right for that kind of conversation. There wasn't. I didn't perceive any movement from the other side of the room to encourage that, and we never really talked about it. We went to trial.
Let me just chime in on that, if I might. With respect to Bill Rogers, his position was, why am I here? There would never have been any possibility at all, even had it been encouraged, for him to even consider tending a plea of guilty. And I do think that there was quite a bit of differentiation in terms of the facts and the strategy and the final arguments, as I recall, particularly in his case. In both trials. Well, there wasn't one in the first one, obviously, but in the second trial, there was a great deal of differentiation. And I'd be remiss if I didn't correct the record. I believe he died in 2004, and he served only 6 months as a resident of the halfway house. He didn't serve any jail time because Judge Taylor, after all the appeals were exhausted, I believe it was pursuant to a Rule 35 motion, which in those days we could use, can't do it today, granted that and gave him, reduced his sentence to serve a period of time in the halfway house, which is not part of the record so far that I've been able to see, but thank you.
Bill, in terms of choices for defendants, I know you had a comment that you wanted to make about that.
Yeah, I probably hold a record for the youngest member of the defense team. I had graduated from law school in May of 1976. Was actually sitting at counsel table with Joe DePaul representing Ernie Corey, having not had my bar results yet. And was actually petrified that if I failed the bar, I would never show my face in the state of Maryland again. But I often wondered.
So did you pass?
I did. I managed to pass. And then trial 2, I was with Chuck Bernstein and yourself, Mike, representing Ernie Corey. And what I often literally really didn't know, learned from all the excellent lawyers that I observed. It was a great opportunity for me as a young lawyer to see lawyers, good lawyers, great lawyers in action. But I often wondered, because what I know now, 30 years hence, we had a client that in his heart believed he had done nothing wrong. He was a lawyer, and I don't think that he really had much, certainly had no criminal experience, and I don't think he really retained a criminal lawyer to advocate on his behalf pre-indictment, because when Joe was hired in the case, I think he was hired after the indictment and before the arraignment. And I often wondered, as I look back on it now, that Ernie went in before the grand jury, I think, without looking at his file, testified without the benefit of counsel, firmly believed that he had done nothing wrong, and he basically talked himself into an indictment. And I often wondered as the years go on that, now I think a lot of good lawyering can be done pre-indictment. That had Ernie had the benefit of a counsel that really engaged, the U.S. Attorney's Office, had he had the benefit of really sitting down and understanding his file, talking to the government, he may very well have been a witness and not a defendant. And as I look back on my experience from the Mandel trial, that's what I come away with really is, in addition to watching great lawyers in action, is you can do a lot for a client pre-indictment, and I often wonder if we'd been involved earlier, whether Ernie would have been a witness and not a defendant. That's what I come away with the trial.
Arnold?
I want to say for the record, here and now, the governor never offered to put in a plea and testify against Mike's client.
Barney, if I could ask you a couple of questions, and you guys can divide these up, but based on some of the comments we just heard, were you surprised that somebody like Ernie Corey didn't try to come in and become a witness as opposed to a defendant? Were you surprised that there weren't entreaties from the other side about plea bargaining? Were you surprised that, or did it strike you that all the defendants were on the same page and that you didn't get the advantage of the multi-defendant pointing the fingers at each other? Or did you think there was more of that going on than has been indicated? There are a lot of questions, but I have a lot more for you. So answer whichever ones you want.
Well, I think Ernie Corey, had he come in and like a lot of other folks in a lot of other cases, had he said, in essence, I will tell the truth about what I did and who I did it for, I have little doubt that he would have ended up a witness instead of a defendant. Fact is that he had in very significant ways aided and abetted the monstrously complex fraud that was committed, and to the extent that he spoke to us or to the grand jury before indictment, he spoke in ways that were not truthful. So to say that he talked himself into an indictment, I think, is essentially accurate. But I think it's also probably true that had he told the truth, which would have been very damning for the other defendants, all of whom were clearly more culpable than he would have been a witness, and probably a very significant one. I would like to say a word or two about some of the things you've heard from the other table.
Thank you for not disappointing me.
I can't hear you.
Oh, I'm sorry.
I want him to hear you.
Yeah, I'm sorry. Can you hear me now? No? Is it on? Okay. These fellas are very good lawyers, which among other things means that they are capable of the forceful articulation of nonsense. What
I thought you'd reform.
What has happened in this case, because of the technicality of the mail fraud statute 10 years after we used it in accordance with the precedent that existed at that time, being reread by the Supreme Court, and for a year between 87 and 88, when Congress explicitly said that what we had done, that the mail fraud statute does mean what we had understood it to mean. But during that year, the quorum nobis petitions were filed and were successful. What has been done essentially is to muddy the distinction, and this is what Arnold's presentation does, muddy the distinction, which really needs not to be muddied, between whether or not what the defendants did was, as a legal matter, prosecutable under the mail fraud statute. That needs to be distinguished from the factual, non-legal question of just exactly what did the defendants do. What the defendants did was a monstrous bribery scheme. Arnold said, well, they could have easily brought a bribery case, but they didn't. Well, we couldn't bring a bribery case because bribery of a non-federal official isn't a federal crime, at least wasn't then, as far as I know, still isn't. State prosecutors could have prosecuted the sitting governor for bribery. I mean, they had the statutes with which to do it, but nobody was holding their breath waiting for that to happen. So, armed with what resources we had, which were significant, but which did not include prosecuting what was a monstrous and complicated bribery scheme for bribery, we used a statute, mail fraud, which was at that time in the law, usable for the purpose we used it. And it was only 10 years later that the Supreme Court, in an unrelated case, said, no, actually, you can't use it for that. Put the legalities aside. The defendants, the private citizen defendants, gave Marvin Mandel over $300,000 worth of value. Not cash in envelopes like Agnew and most of the other cases, but very complex business interests in real estate deals. And yes, there were some suits, but nobody prosecuted for some suits. Over $300,000 in 1970 dollars. It's a lot of money in value. Totally hid it in very complex documentary, hidden nominees and all the rest, backdated letters. Indirect quid pro quo return for the governor's using his very considerable influence to see to it that legislation enormously beneficial to his friends was passed, or in one case, temporarily not passed, but ultimately passed. This was bribery. This was a huge, very complicated, very sophisticated, and very, very well-hidden bribery. It wasn't prosecuted as bribery just because we were federal and he was state. All you have to do, I mean, don't take my word for it, all you have to do to know that what I'm saying is accurate is read the facts of the case. Forget for a moment whether it's mail fraud or not. Just read the facts of the case. Read what was proven. What was proven was a monstrously complicated and very successful bribery scheme. So when Tom says, well, that's their opinion, that something wrong was done. It's true that it's our opinion. It's also true that it was the unanimous opinion beyond a reasonable doubt of 12 jurors. Yes, there was an Allen charge because, as we found out after the horrendous 10-day jury deliberation and finally the verdict, we found out that the jurors were split 11-1, and this one juror who had doubts caused the Allen charge to be given. But it was always 11-1 for conviction, and ultimately 12-0. So it was a little more than our opinion that this was what it was.
Okay, thanks, Barney. Chuck?
Barney, can I ask you a question? If it really was a bribe and a quid pro quo, how come you argued for almost an hour to the judge not to give an instruction requiring a quid pro quo, and in fact prevailed on that, which would have settled the question of whether there was a bribe or not? Weren't you really afraid to have to take that burden on before the jury? And if not, why did you argue it?
Oh, Arnold.
There you go again, right?
If the case is in court under the mail fraud statute, which doesn't require a quid pro quo, and a defense attorney says, Judge, instruct the jury that they have to find a quid pro quo, any lawyer who knows what he's doing, including, I suspect, Arnold, if he had been on that side, would say to the judge, no, don't make them find something that the law doesn't require them to find. Again, to conflate proper jury instructions in a mail fraud case with the facts of the case, to say that, well, if there was a quid pro quo, the judge should have to tell the jury they have to find a quid pro quo, even though it's not being prosecuted as a bribery case. That's kind of not what lawyers do. So we argued to the judge that since it was a mail fraud prosecution, he should charge them on the elements of mail fraud, which seems like a reasonable position to take. And he did, and they unanimously convicted the defendants. But again, don't take my word for it. Just read the facts of the case.
Chuck, as a judge, you're really letting lawyers go on and talk here without saying anything. I'm a little surprised. It's atypical from my experience.
Well, I find it, number one, I have to fight Arnold for the microphone.
No one has ever won that battle except Arnold.
The most dangerous place in Baltimore City is between Arnold Weiner and a microphone. And I say
I thought I was sitting with friends.
And I say that after sitting in a Baltimore City criminal court for a year. It was interesting listening to you guys. Along with Mike and Bill, I represented Ernie Corey, and it's one that frankly has weighed heavily on me for 30 years. I was in it, we were in it for a short period of time. We weren't there pre-trial. Joe DePaul had him at the first trial. Ernie ran him money, he was destitute. And Joe was a smart guy. He knew when to get out. And there was a public defender, and we got into it with Mike and Bill. And then, I think, tell me if I'm wrong, guys, but we got out pretty quickly, too, after the appeals. We weren't around for McNally. We weren't in quorum nobis. We weren't in forfeiture. And I have to tell you, I don't live in the past, and once it was gone, we had lots of ordinary crooks to represent in the public defender office, and I didn't keep reliving it. But last night, in my usual last-minute preparation for this thing, you had mentioned, Mike, at the Zuckerman affair that Ernie had been reinstated at the bar, and I went and I got the opinion. And I hadn't been aware of that either, I don't think. And the opinion was by Judge Radowski, who got it right, as he usually does, allowing Ernie to be reinstated, I think before McNally. I think before that came down, and crucial in that, I think I've got this straight, were three things. Number one, Timmy Baker, who was then the U.S. attorney, went before the judge and argued for Ernie, I guess it was under Rule 35, to get probation. And there were letters that Judge Radowski looked to from Barney Skolnick and from Judge Taylor recommending that Ernie be reinstated to the bar. I do think it was a tragedy with him. If he'd been handled properly, he'd been a witness. He lost everything. He wound up destitute, according to the opinion. He was cutting firewood for a living, which is okay if your name is Hillel. It's a little rough if your name is Corey. I do feel that had we gotten a severance, which I don't think there's ever been one in the Fourth Circuit, but if we'd gotten a severance, I think we would have beaten you guys. I really do. Tied in with these guys, where it was just week after week of corrupt governors and incredible testimony. We had one secretary come in and say that she'd confronted Mr. Corey about something, that he didn't have any scruples, and he allegedly said, well, you can't eat scruples for breakfast, and it was just inflammatory testimony. It didn't have a great deal to do with anything, but it all came in, and I think for Ernie, frankly, it was a tragedy, and I think it was a tragedy that could have been avoided, but, that's the way it goes. Arnold has to, showing his age here.
Yeah, I think Ernie's one, he went to his death firmly believing he was innocent and should not have been charged in this case. But
I think the problem with Ernie was that he allowed himself as an attorney to represent to everyone in Maryland that Eugene Casey owned the Marlboro racetrack. Eugene Casey's the guy's name you see, the Eugene Casey Foundation.
He made his mistakes, Dan, but he didn't get a nickel out of any of this. He benefited
Well,
not one
he was
penny.
he was a lawyer, a member of the bar,
Let Dan finish.
and he was used by this crowd to con everybody in the state, because the only way the scheme was going to work was if nobody knew that Hess, Rogers, and
did some
Covens
things
owned
he
this
shouldn't.
racetrack. And that was the key to the whole thing. So at the same time they buy the racetrack, all of a sudden all these racing days start flipping into the Marlboro racetrack. At the same time, Marvin gets cut in on a 4/9 of Dale Hess's interest in the building that sits out there at the Beltway, where the Social Security Administration is housed. All of this happens within about 2 weeks. And the night before the override, I don't remember all this all the time. I found the brief in my basement. 20 phone calls were placed from the Tidewater Insurance Agency to the governor's office just before the override. And the day of the override, I don't know about snakes, Roy Staton, the governor's top guy at the time, told other senators that he wouldn't mind if the veto of his bill were overridden. I don't know about snakes. This was testimony, and Roy Staton testified. There's no hearsay problem.
I have to tell you, last night Barney and Dan and I had a long dinner, and it was really fun because Barney and I were listening to Dan saying things like, "We did what? We did that? Really?" So we're all very well prepared today, thanks to Dan and dinner last night.
I'll tell you, I got to tell one. There haven't been any war stories, but I got to tell two about Barney, because they illustrate two great facets of his incredible personality. One is, I think he's the best trial lawyer I've ever seen in a courtroom. When Marvin Mandel testified, and the national press was there that day, everybody was there, in the middle of his testimony, he says to Barney, "You know, I renounced my interest in the security investment company." And this was a key bribe in the case, really. And Barney said, "You did what?" He said, "I renounced my interest. When I became governor, Dale and I discussed this or decided it was wrong for me to be in this relationship, so I renounced it." And so Barney said, "Well, how'd you do that?" He says, I wrote it down. It's a document." And all of a sudden, all of us go, "Oh, my God." And he says, "Where is it?" He says, "I've got it right here in my pocket." So he pulls out a napkin. And he says, "Here it is, written on this napkin is, I hereby renounce my interest in Security Investment Company, Marvin Mandel." So Barney looks at it and he says, "Judge, can I have a minute to discuss this development with my colleagues?" So he comes over to us and we all kind of lean in together, Pete Tortowitz and Ron and Barney, and I'm figuring, well, Barney is brilliant, he's going to have something here. And he goes, "What the hell do we do now?" So he walks back over to Mandel.
Well, you have to say, we went.
We didn't have anything. He goes back over, and the governor's sitting in the chair, and he's kind of got a cocky look on his face, like, "I've got you guys now." And so Barney, he does this. He says, "Give me that napkin." Looks at it, and it's dead silence. It's 500 people are waiting for the next move. He goes, "A napkin! A napkin! You renounced an interest worth $300,000 on a napkin!" Just like that. There wasn't any question. That was and Mandel starts to kind of look a little. And I think we won the case, right there. The other thing I got to tell you, and this is a story that has never been told. In the middle of the first trial, we got a phone call from I'm not going to put any names on the table, from a young lady who called us and said, "I think I have some information you guys want." And so Barney, I think Ron was off preparing for a witness. Barney and I met with her in the conference room at the U.S. Attorney's Office one Sunday afternoon. She comes in, and my wife's here, so I can't describe what she looked, but she was very attractive. She says, "I don't know if this is of any interest to you guys, but I've been following the trial, and I was with the defendants the night in the hotel room in Annapolis, the last night of the legislative session. I was a girlfriend of so-and-so. And I don't know if this is of any relevance to you, but all night long, I remember this, Dale Hess was on the phone with Marvin Mandel. And because I couldn't hear Mandel's end of this conversation, but Hess kept screaming at him, you know, what are you going to do? What are you going to do? How are you going to get this thing? That was the night that the consolidation bill was in front of the legislature that would have given the track another 58 racing days. So here she is, our dream witness. She ties the whole thing together. And Barney and I looked at each other and we said, oh my God. And the next 2 days were spent with a whole team interrogating her, trying to figure out if the story was going to hold up. Because we had a great circumstantial case. If we put her on, she was going to become the whole thing, because she literally, if what she was saying was true, it tied the whole thing together. We sent Tortowitz out with her, Pete Tortowitz, the late, great Pete Tortowitz, our IRS guy, and he drove all over Baltimore County with her. He later confessed he was somewhat distracted by her appearance and wasn't paying that much attention to the thing. Finally, after great debate, we decided not to call her as a witness because we weren't sure. Well, let me tell you what. Before that happened, we announced her name to the defense and the judge. But tomorrow we're going to call so-and-so custodian records, and we threw her name in there. My job was to look over at the defense lawyers, particularly Arnold, and try to see if I could see any kind of reaction. Because normally if we announced a witness who Arnold didn't know who that person was, he would go crazy and scream and holler that he hadn't been. And this one, nothing. The defense lawyers, oh yeah, okay. And Hundley was the same thing, just stone faces. So we all go back to the room and we argue for hours. Should we call her? Is this a setup? You know, is she going to get destroyed on cross? Blah, blah, blah.
She was a plant.
And in the end, we decided not to call her. And I guess why I say that's a great thing. Here's a guy, this whole case could be made, clearly made. And we have a great lawyer. But if we had put her on, and he basically said, I'm not going to use her. And I think that, to me, is a sign of a great lawyer, that he has enough confidence in his case that if a piece of evidence comes to him that most lawyers would say, go, God, that's great, he chose not to use it.
I would just like to, as a personal privilege point or something, I would just want to say another word or two about Pete Tortowitz, because you mentioned Pete. And Pete was the world's greatest investigator, and he was with Barney and his team every step along the way. In this case, in the congressman cases, in the county executive cases, in the Agnew case, Pete had a facility for talking to people and getting them to talk that was just unbelievable. Pete Tortowitz could pick up a pile of canceled checks and sort of flip them through his ear and detect the ones that were the evidence of the crime. And on top of all of that, he was just a wonderful human being who was a pleasure to spend time with. I miss him. I know everybody who ever worked with him or played with him or lost money at cards to him also misses him. And so I just want to take this opportunity to acknowledge his role in this case, which was a substantial role. So,
right, was she a plant or not?
That's right.
I already asked him that question. He won't answer it.
I cut you off before when you had something you wanted to say about Ernie. You remember what you were trying to say? I think I cut you off before when you were. Okay. Well, I'm sorry then. Does anybody want to talk about the two trials and what, if anything, was different in them? My recollection, and I did not participate in the first trial, Covens was not a defendant in the first trial. Is that correct? Because of his health or something else? And so I guess a question that I have is, was there a difference in the two trials? Was there a difference in the defense approach? Was there a difference in the government's approach to the trials? And was there a difference in the two trial judges that influenced how the trial was conducted?
Let me talk on the judges, because I had interviewed and spoke with both of them. And from the press point of view, that may have been the most dramatic difference. John Pratt was a player, a politician, a tyrant in the courtroom. He ran the show. He met with you guys every morning and wanted to know where everything was going. He had meetings with the press. I looked at some of the transcripts a few weeks ago, and I think maybe a third of the day was spent in bench conferences as opposed to trying the case, and he was always manipulating and micromanaging everything. I think we had a 2-week negotiation with him at the beginning on how we were going to get access to the bench conferences that were open to the public, but not to the jury, and we finally worked out daily transcripts and all of that stuff. Robert Taylor, I went down to interview him and do some background stuff on him, and I asked one of the lawyers down in Tennessee how he handled motions, and he said, "What motions?" We don't have motions in this court. We go to trial. We try our cases. I bet there weren't 4 bench conferences in the entire second trial with Taylor. You asked a question, you made an objection, he had sustained or overruled. And that's where it went. Well, it depends on whose objection it was, right?
Well, there was a big difference in these trials. We lost our best trial judge. I think
Judge Murray.
No.
Now, Judge Murray, now there's a story, Judge Murray.
Yeah.
When Judge Murray was the first judge, and when he looked at me and I looked at him, we did not like each other.
I'm shocked to hear that.
And Judge Murray had to leave the case, but he left not a happy man. Okay, he did not want to leave the case. We felt that he clearly could not be impartial. I was nominated because I lived in the District of Columbia and did not have to confront on a daily basis the judges in Maryland. I was nominated to go tell him that he had to recuse himself. I did tell him that. And he told me to go sit down and shut up, and he was going to stay on the case. So I then mandamused him. We went down to the Fourth Circuit, and I'll never forget that. I had worked on my argument. I was ready to be eloquent, and they called the case, and we were introduced, and I stood up, and I don't remember which judge it was. He says, "Mr. Green, sit down. Sit down. You don't need to say anything." I don't know which one of you guys, was it one of you guys that argued?
Yeah.
But he said, he said, "We'll hear from the government, and the first question is, tell me one good reason why Judge Murray should sit on this case." And that was the end of Judge Murray. And no tears were shed for Judge Murray. Then came Judge Pratt.
Well, there's more to the Judge Murray story that I thought was interesting. When Tom says that he was a young lawyer at that time, he's not kidding, because all of us wanted to get rid of Judge Murray, and we all decided that the one guy we could talk into filing the motion was not. I'll never forget Huntley saying, "Let Greeny do it." And Judge Murray calls us all. The problem was this: Judge Murray's brother-in-law was dying to get on the bench to be appointed a circuit court judge in Baltimore City. And it was clear that the governor would not appoint him. So he was writing, here the judge's brother-in-law is writing letters to the editors saying, "I hope the guy gets convicted so we can have good judicial nominees." And it was his brother-in-law was going to preside over the case. So we all knew we had to do something. So Greeny gets set up. He files the motion. And Judge Murray called us all in to his chambers. And his idea was that unless it was unanimous by all the defendants, he was going to just squash whoever was going to complain. So he starts off, of course, Greeny, he's not looking Greeny in the eye, and he's moving around the room, and he goes to Huntley, "Do you agree? Are you joining in the motion?" "Yes." "Mr. Greeny, are you joining?" "Oh, yes." And finally, he saved for last Norman Ramsey, who had been his dear friend, and he thought that if there's anybody in the world who would not join in the motion, it would be Norman. And Norman was a great lawyer and a great guy. And he said, "Judge, I'm sorry, but I think you shouldn't serve in the case." And if there ever was a real reason to tell you how personal it had gotten, when we argued before the Fourth Circuit, remember, these are all judges in the same judicial circuit. Judge Murray brought his wife to the courtroom to sit on the government side, and the Fourth Circuit, you know, has this custom of coming off the bench and shaking everybody's hand. Well, when they came off the bench, she rushed to the front to shake the judges' hands, and not one of the judges would shake her hand. They knew the whole thing was inappropriate. And what they did was what the political thing that appellate courts do. They said, now that we've expressed ourselves, we assume that Judge Murray will make his own decision, so we don't have to enter an order. And he was gone. It was a shame because Judge Murray was a good judge, but it was something about the Mandel case that got people doing things that in more sober moments they wouldn't have.
Andrea, did you sense during this trial I mean, here we have lawyers, this case is 30 years old, they're at each other's throats already about it. People remember very vividly, Arnold is making the point that lawyers, including judges, sort of went out of their way to do things that in an ordinary case, I mean, they wouldn't do. Judge Murray was a pillar of rectitude. And here he's bending over backwards and saying, okay, did you have a sense of that at the time when you were covering it?
Yes, I think that's what made it so fascinating, because it really reflected everything about the fabric of politics at the time, and perhaps today. But the relationships were so complex, and it involved the way legislation progressed through the state house. It involved the way the governor and his friends worked. I mean, the bigger question that still has brought us into conflict today is whether that way of life was a violation of the law. And, you have Arnold saying one thing, and obviously everyone on this side saying that it was, no matter what happened in the subsequent appeals. But it certainly put on trial not just the individuals. It put on trial a way of life in Maryland, and as Arnold referenced, in other districts as well, in Chicago and New Orleans. It was a microcosm of politics in America. And that's what was the larger narrative, I think, that made it so fascinating.
Thank you. We were just talking about the recusal of Judge Murray. Was that the only judge that got recused in this case?
Well, I mean, then we got Judge Pratt, came up from the District of Columbia, and I had a long and fuzzy relationship with Judge Pratt because as an assistant U.S. attorney, I was assigned to his courtroom for a number of years, so I knew him quite well. And, we got into this whole issue of the jury tampering, which I can tell you most assuredly was a shock and surprise to me as it was to others, and still don't understand all that I think there probably is to know about that, those incidents and what happened. I really don't know. But Judge Pratt, and someone may be able to correct my recollection here, I have this this recollection that you guys sent me in again with Judge Pratt, because Judge Pratt had said something to the press that was deemed to be, or we thought was inappropriate, and so you guys collared me again and said, you got to go do it again, Greenie. You got to go back in there and seek to recuse Judge Pratt. And it was a very difficult moment for me because, I knew him so well and I was so conflicted, but I did my duty. I stood up there and I made the motion and there was dead silence and he was looking at me, I'm sure, just horribly bewildered as to how this lawyer whom he knew could do this to him. But what eventually happened is that, he did take himself off the case. I thought he would have been the best trial judge of the three. And I don't mean just for us. I just think he was I don't know if Lee would agree with me. I did not have the sense that he was micromanaging as much as you seem to remember. But he always struck me as a very fair guy who tried to just call him as he saw him. And I thought Taylor, I thought Taylor was handpicked for this. I thought, that was just the stroke of the forces of darkness above us, and reaching down to Tennessee to find Bobby Taylor and bringing him up here.
He had tried auto code.
Yeah, for sure.
He did have some experience.
And that's
Let me tell you a Taylor story.
a perfect guy to choose, right?
Man to get control of this.
That's right.
One of the most regrettable off-the-record conversations I had was with Bobby Taylor before we started the interview, and I did pass this on to Arnold because it was important enough that you should know it. But I walk into his chambers 2-3 days after he's named as the trial judge, and I'd been down in Tennessee for a day or two talking to lawyers and looking at a bar survey, and I mean, he was roundly hated by the criminal defense bar as a judge with no tolerance for anything. You came into court, you tried your case, and you got sentenced. But I walked into his chambers, and he looked at me, Mr. Balin, you're from Baltimore. He says, now tell me why that Johnny Unitas left that nice wife of his and ran off with that bimbo. I said, Marvin is really in deep. Those of you young people out there don't know, this whole case was about a guy who needed money for his divorce. And the parts of the bribes were a diamond bracelet because he got in an accident and got caught visiting his girlfriend. Later, his wife, and a lovely love story that goes on forever and ever. But at that point, it was a very sordid sort of, his buddies are buying him diamond bracelets to pay off his wife because he got caught at a late night rendezvous. And here's Bobby Taylor saying, why did Johnny Unitas run off on that nice wife of his? So I thought Marvin was going to get, I thought it was going to be the first consecutive sentence in a political corruption case.
Well, we knew what we were in for. Judge Taylor gets appointed, and we wanted a change of venue. We thought the place was pretty saturated with publicity. So he said, he sent word to us, file your motion by 9:30 in the morning, and I'll hear it at 10. And we filed the motion with a carload of exhibits. And at 5 of 10, the judge got on the bench and said, I've read every paper. And the motion is denied. And from then, it got worse. He would start early, we'd end late, we'd sit on Saturdays. We even sat on the 4th of July, and the irony was that the witness was a fellow named Christmas. It was Christmas on the 4th of July. It was an experience. The only thing I got out of it was he liked me personally, so he would turn to the press corps and say, "That's a good lawyer."
Go ahead, Chuck.
My question to Tom, since we weren't in on the first one of the things I heard was that Judge Pratt was of the view in the first trial that Ernie was the mastermind behind all this. That abated somewhat with Taylor. Is that your recollection, or?
It's not my recollection, but I have so little recollection of 30 years ago. No, I don't recall that.
The first trial ended because after the close of the government's case, just after the close of the government's case, before any defendant testified or any defense witness, I believe, was called, I may be wrong, a bribe was offered to one of the jurors. The bribe was offered to a gentleman named Oscar Sislin, who drove a limousine, and it was offered by his brother-in-law, who, I forget his name, but I was actually sent out to arrest him, along with the FBI, at a furniture store in northwest Baltimore. And this guy...
Not PM Coven's furniture store.
No. But a furniture store in northwest Baltimore. And this guy turned out to be a little old man who had never done anything wrong in his whole life. And he, for some reason, which we still don't know, decided right after the close of the government's case to offer a $10,000 bribe. And then, of course, the juror came to us and came to you guys. I mean, we all went to the judge. Jury was all put into the hotel room. And they had a television set in the room, the common area, which the marshals turned off for the news. But they didn't turn it off until 11 o'clock. At 10:30, even in those days, news at 11, bribe attempt in the Mandel case. And that was the end of it. And Pratt, I believe, just gave up. I think he was worn down. I don't think he recused himself. He just declared a mistrial and went home.
I was wondering, when you talk about the saturation effect of all of this, what did you do differently in the second trial in terms, if anything, in terms of jury selection? And how important was the process that you used and that you all used in terms of selecting the jury?
Well, we did them both the
trials.
same way, which was, and now it's a commonplace, then it wasn't. We went and had a jury consultant who went out, did surveys, and the best you could get was the demographics of the juror who's most likely to be sympathetic to the defendant. Well, needless to say, we didn't have to spend all that money because in the end, it was somebody who didn't read the newspapers and didn't have a lot of education was the person who was said to be the least likely to be poisoned by all this. But these jury attempts, the worst. I mean, it's one thing to have a blow to your ego at the end of the government's case. There were two jury foolishnesses in that case. The first one was right after I made my opening statement. I got back to my office, and there was a call from a fellow from New Jersey. And he introduced himself, and he said, "I understand you just made your opening statement." I said, yes, sir. He said, "You're going to lose." "But I have a friend on the jury, and I can help you out." And I gave a different opening statement the second time, but I went right to Judge Pratt and reported him, and it was that bribe attempt that was the subject of the news, that news flash. It was Mandel jury locked up, now news of a second bribe attempt.
You know, I maybe with you, Barney, I tried that guy, Charles Nieswinder, I think his name was. Fred Motz defended him, and we really wanted to know who put him up to it. And after we convicted him...
Well, we knew, we just wanted to prove it.
It's always been the case.
I'm not going there. After we convicted him, with, as I recall it, with Fred's approval, I spoke to the guy and said, "Look, you're about to be sentenced. We really, we could work something out here if you'll tell us." And I don't remember his exact words, but it was something to the effect that he'd be better off in the long run serving some time than telling us who put him up to it. I'll never forget that.
Didn't Charlie from Cinnaminson also work in a furniture store?
Listen,
Charlie Nieswinder, he was from Cinnaminson, New Jersey, right?
Listen, just so you don't think that these people are crazy about retrying this case from 30 years ago constantly, Fred Motz, about a week ago when I was talking to him about this case, still insists that he had a perfectly good legal defense to this Nieswinder case. He can't believe the district judge didn't buy it and the Court of Appeals didn't buy it. I think what we're going to do now is throw this open to some questions from the audience, and I'll start right here. Rod?
I have a question. It's probably best directed to Governor Mandel's lawyers, but in their absence, maybe Tom Green could address it. That is this issue of the absence of any allegation of political motivation. Today, if the U.S. Attorney were to bring a case on a slim evidentiary and legal theory against a sitting governor of the party opposing the president of the U.S. Attorney, I have little doubt that the defense attorneys would come forward immediately and allege political motivation. And now we're in a time where we have this bureaucracy of career AUSAs, career prosecutors that made justice to review indictments. In your day, you had assistant U.S. attorneys who were generally
Term limits.
who were generally shared the political affiliation of the U.S. attorney. Why didn't anybody allege political?
Well, with all due respect to the current Justice Department, or at least the most recent current Justice Department, we didn't have 8 U.S. attorneys fired on dubious grounds. No. Back then, there was never a question about whether the Justice Department had dipped its hands into politics. The Justice Department went for many decades without being besmirched that way. And I must say that if there's anything that the current administration has not to be proud of, it's the fact that they have created a climate in which that kind of motion that would never have been brought is now a commonplace.
It didn't start this year, right? I mean, these kind of allegations have been made at least for the last decade, 15, 20 years.
I haven't seen him as much as I've seen him recently, and some of these very important, the governor of Alabama, some of these very important prosecutions have been very much brought into doubt. We never had, I can't remember a U.S. senator calling a prosecutor in any previous time to ask the prosecutor, when are you going to get the indictment out in this investigation? And after being rebuffed, the U.S. attorney then finds himself fired. I mean, there are things that have occurred in the last few years that give rise to healthy skepticism. And I must say, we never thought about it because we had no reason to think about it.
Well, I think for some period of time, it's hard to date it, but clearly those of us who defend public figures have suggested that there's a political context lurking in the background, but it's never really resonated. It hasn't got much traction. It's hard to drive that argument, very far when there's complete resistance to it in the Department of Justice. Things have changed dramatically. I mean, even today, I'm representing the Democratic governor of Puerto Rico being investigated by the Republican U.S. attorney, and I can assure you that we are, ringing the bell on political influence, and have actually gotten 2 or 3 internal investigations commenced at the department looking at this and so forth. So it's just right now. It resonates, and deservedly so, I must say. I mean, the department is in sad shape. I don't even know if the proposed AG, nominated AG, is going to get confirmed, but it's a mess, and they've made their own bed in some respects, and so now we're trying to exploit that argument a lot.
I mean, what did you have back then? You had Elliot Richardson as Attorney General, who stood up to the administration. You had Bobby Kennedy when he was Attorney General, not only authorizing the prosecution of here in Maryland, of 2 Democratic congressmen, one of whom had been a close friend of his father's, but actually volunteering to be the star government witness when a fix was attempted. I mean, you not only had in those days an absence of reason to suspect, you had lots of things happening that gave you lots of confidence. Well, and get. Well, but look, the good guys won out in that.
Dale?
Yeah.
Curious as to what actually prompted the government's investigation of Mandel. I know it followed on the heels of Agnew and county executives, and there's always been a rumor in the U.S. Attorney's Office that Barney said to Pete Portowitz, here's the bank record, see if you can find a crime. I suspect there was more to it than that, but I'm curious if they could share with us now whether there was some witness who came in, there was some documents from one of the other cases that prompted them to look into Mandel's finances, or exactly what started the ball rolling.
In the late 60s and well into the 70s, the atmospherics in Maryland about people who cared about such things was that just about every public official was on the take. That was, of course, not true. There were plenty who weren't, but there were plenty who were. And as somebody said earlier, it was long-standing, it wasn't new. A lot of them were doing, and ultimately, at least publicly defending themselves on the ground that they were not doing anything other than what all their predecessors had done, and so they thought it was perfectly okay. The point is that in addition to the general atmospherics, there were tales told to and by legislators, to and by businessmen on whom the arm was being put. And I don't mean tales that were being told to prosecutors. I mean tales that were being told by these people to these people, and one heard them. One heard, for example, that the Tidewater Insurance Company, which, starting when Governor Mandel became governor, had a very steep curve, upward curve in the business that it was getting from the state of Maryland. Bond and insurance business, Tidewater being Hess, Rogers, and Rogers. One heard that this was not a coincidence, that the governor was seeing to it through his intermediaries that Tidewater did very well. We determined early on, this is early '74, that there was enough. I mean, I don't remember any specific witness coming forward initially, there may well have been one, but that there was enough rumor and story and atmospherics to justify a subpoena to Tidewater, which is how the whole thing began, for records of its state business. And those subpoenas were issued, I think, in March or April of '74, and the whole thing took off from there. It was not initially, and really for a long time, an investigation of Governor Mandel, although everybody knew that if Tidewater was dirty, it was dirty with Governor Mandel. So the initial objective was to see if we could, initially through its records, who it was doing business with, and then you bring in those people to say, why did you do business with Tidewater? And very quickly we started to get people saying, I was doing business with Tidewater. These are businessmen now. I was doing business, putting my insurance with them or getting my bonds, my construction bonds, completion bonds through them, because I was told that the way to get work from the state to build a library or whatever was to do business with Tidewater. Well, who told you that? And then, you know, the thing snowballed actually very quickly. We didn't actually have any evidence directly against Governor Mandel until late '74, early '75. But that's the way it began. And that's actually the way most of those investigations began. And a number of investigations of different people began that way and never went anywhere. You know, ideally and usually in those days, the public never hears about investigations that don't go anywhere. I mean, that are pursued to a certain degree and for a certain length of time, and there's no case, or at least there's no provable case, and the whole thing dies within the U.S. Attorney's Office. Nobody knows about it. The ones you know about are the ones that lead to indictment.
Any other questions? Yes.
Yeah, I was active politically in that era, and it was common knowledge that Mandel needed money, and Herb Kovens was getting him money, and Mandel ran the legislature, and there was no way those racing dates could have been given other than Mandel's approval. But what bothers me about the prosecution and this culture of prosecution is that it is true that one rewards their friends. They give them jobs. I mean, what about President Bush and Halliburton and the oil companies? Couldn't you say the same thing? I remember Steve Sachs went after a commissioner in Prince George's County and convicted him, I happen to know that commissioner, on an atmosphere of corruption. That is, they didn't have a specific thing. And couldn't you do it right now?
You talking about Jesse Baggett?
Yeah, Jesse Baggett.
Oh, it was a tractor. It was a tractor. Ralph Rocks gave him a tractor.
I mean, everybody supposed that Jesse Baggett was in on stock deals. He lived in Charles County, and he had some cows. And he went after him for years and years. And I just don't know where the line is. I mean, what is bribery? Is Cheney doing bribery because Halliburton is getting all that work?
No.
Is he bribing? Is he being bribed because he was the CEO? I don't know. It seems to me
I mean, everybody knew that Mandel was doing this. That was clear. I mean, there's no way that could happen. Very effective. But when is the line on bribery?
Okay, it's a legitimate question. Let me give you a short, I hope, legitimate answer. If everybody knew that Governor Mandel was rewarding his friends, it's not a crime, unless his friends are rewarding him, and unless there's a link. I mean, if in fact a sitting governor or any other public official who has the authority to award a job or whatever, render some benefit, chooses to render it to his friends with nothing in return, just does it because they're his friends, it's unseemly and it may be unethical, but it's not illegal. If your friends are lining your pockets with $300,000 of value in return for your doing that, that's the line. And if you have difficulty seeing it, I don't.
Speaking of people with $300,000, Si?
I have a question for Andrew Mitchell. This is a local story, but it was also a national story. And it seems to me that probably happened a lot. I grew up in Northern Virginia. It probably happened a lot at WUSA or whatever it was called back then. How did you view your role in those types of stories? Did you view it as sort of like both at the same time, a little bit of a hybrid, or the opportunity to put your stories on a larger stage? I mean, how did that work? Because there are a lot of stories like that.
There are, and in fact, Channel 9 was unusual because they looked for national implications of local stories. They had me covering the Bakke arguments at the Supreme Court. They, being located in Washington and at that time being owned by the Washington Post, Post-Newsweek, had this national perspective. But I also returned and covered the post-trial issues, you know, for David Brinkley and for the national news. And I think you always look for the broader context. I mean, the good local news operations are always looking to contextualize what you're reporting, and this clearly had larger implications for the state, for the community, and in terms of anyone interested in political science, or maybe that's putting too much of a gloss on it. But it certainly, they were wonderful human stories also. I mean, there was that soap opera that everyone has referred to here, and there was a very human component to it. And certainly Barney and Dan and Ron had a national reputation coming out of the Agnew case, and that had certainly elevated the focus on it. But it was a great yarn on top of everything else, as most good trials probably are.
Any questions from this side of the room? Yes.
Barney, a lot of us remember your passion, the apparent fire in the belly. Have you mellowed at all? Have you regrets? Would you do anything differently?
You mean if I were in the position today, would I prosecute the case differently, or would I not prosecute it?
Fine, start with that. Or anything differently then?
I think the short answer is no. I wouldn't do anything of consequence differently. I mean, I don't think I would want to have that job today. I know that I wouldn't want to have that job today. When you're 66 years old, there's too much. There's too much gray in the world to ride a white horse 60 hours a week chasing bad guys. When you're 30, that's fine, and I'm proud of what we did, but it's a young man's job. And for me, it's a young man's job, and I'm a lot older now, and I'm a different person.
Professor.
So, who is the white horse today? a great deal of cynicism that many people feel who may have experienced corruption in our political system. Well, I used to think that the Fifth Estate was the answer, and that the role of journalism and of investigative reporting, the Watergate report, of course, but it goes so far beyond that. The Baltimore Sun, just as an example, was known for its investigative reporting, and you had reporters that you could turn to, and you had confidences that were held, and they were respected. So have we really reached the point where, and I guess I am addressing it to Andrea and to the reporters, at least in the first instance, have we reached a very different time now where we can't expect the news media to really take the time to devote to these complicated stories, but where the role of the I don't want to pin it on lobbyists, but the role of those who have influence in our legislative circles is such that the public may feel that there is not real access to justice and to that white horse?
Well, in some ways, some would argue that there is more reporting and investigating going on because you have so many other media. You're not relying on local television, national newspapers. You've got an enormous proliferation of investigative work that is going on. I would have some, I have some concerns about the independence of a lot of the work that's being done and the lack of partisanship in it. And I think we still carry a great burden to make sure that investigative journalists are not unduly influenced by one side or another and do not carry advocacy beyond simply the search for truth. So I think that journalism has obviously changed in dramatic ways, not only because of the technologies, but because of the greater influence of advocates and the bloggers. The bloggers have had an enormous effect and are clearly not independent in the way that traditional straight reporting used to be. But they have unearthed a lot of useful information. So I don't think that we have a lack of investigations. There are still some very serious print media who are doing some very good work that I know about in Congress. And we've seen that with even the New York Times, the Washington Post, and some of the national newspapers, and the work that they have done most recently on some of the issues of the war and the run-up to the war and what is going on right now with policy towards Iran. So I think there still is a lot of investigative work. It just, perhaps it's just that the issues are so much more complex and the stakes seem larger that we feel frustrated, many of us as citizens, if not as journalists, that the work is not good enough.
Thank you. We are out of time here for this panel. I would hope that you would all join me in thanking these panelists.